For both of you.
On the record in the matter of the people of the city of Lansing versus Tiana Alexander, file number 22-03276. Ms. Alexander, raise a date set for an arraignment for a probation violation. I have here a request and summons for probation violation. It alleges that you committed the following technical probation violations. It says you failed to submit to random testing per EverHealth, and that you failed to test on May 27th, May 28th, June 8th, June 12th, June 18th, June 28th, and July 5th, 2023, as ordered by the court as part of your probation conditions. So you have the right to be represented by counsel, and you have the right to have a contested hearing. You have the right to require the prosecution and which is the city attorney's office and the probation department to put forth evidence to establish their burden as to whether or not you violated the terms of your probation as alleged. Do you understand your rights? Yes. Okay. Did you want to request an attorney to represent you? Okay. You already met with Mr. Lee today?
No.
He was your attorney in the underlying matter? Is that a yes?
Yes.
Okay, well, this is a probation violation, so you're requesting public defense to represent you again?
Yes.
Okay, we'll get you on a device. You have your phone with you?
Yes.
Okay, we'll get you on so you can meet with him so that he can get information he may need from you, and then we'll set this for a hearing.
August 8th at 1:30.
August 8th at 1:30, okay? Do you have any questions today, ma'am? You're all set for today.
Yes, I just have to figure it back out. That's why I came in person.
From the record in the matter of the people of the city of Lansing versus Danny Lang, Senior, file number 19-05001. Mr. Lang, today is the date set for an arraignment on a probation violation. I have two separate violations that you need to be arraigned on. The first is a request and summons for probation violation that alleges that you tested positive at EverHealth on June 24th for alcohol with a result of an ETG of 11,125 nanograms per milliliter and ETS of 2322 nanograms. And on June 26, 2023, with a result of ETG 6,286 nanograms, ETS, and 25,000 nanograms. Then I have an additional request and summons for probation violation indicating that you tested positive for alcohol at EverHealth on July 6th. Again, for alcohol with an ETG greater than 25,000 nanograms, ETS 14,175 nanograms. So you have the right to be represented by an attorney. You have the right to have a contested hearing. Do you understand that?
Yeah.
You have the right to have the probation department and the prosecution, which is the city attorney's office, put forth evidence to support their claim that you violated your probation terms. Do you understand that?
Yeah.
Did you want an attorney to represent you? we'll make sure you meet with Public Defender's Office today. We do have Mr. Lee and Ms. Donnelly both here today, so we'll get you in the room with one of them. And then we'll get you a hearing date, okay? August 8th,
Yes,
1:15. August 8th at 1:15. You have any questions? Okay, do you have a device with you to get online? Onto Zoom?
I got a phone, but I don't know how to use it.
Okay, but it's a smartphone, you can get on an app with it? Okay, when my court officer returns, we'll have him get you in there, okay? You can have a seat. Okay, Mr. Lee, I'm gonna put you in the room with Miss Alexander, and then Miss Donnelly, I'll put you in the room with Mr. Lang when he's on the device.
Thank you, Your Honor.
Thank you. And then we'll get Mr. Coops in here. Good afternoon, yeah.
Oh, okay, just kidding.
Good afternoon. You get Mr. Lang in on the Zoom as well. He said he has a phone with him.
Sure.
All right, to the jury. Welcome back, everyone. You can take your seats. Okay. Thank you, everyone, for being timely, and we are going to continue with closing statements.
Ladies and gentlemen, I thank you for coming back today. Yesterday was kind of a long day, going 7 o'clock last night, but I'm not worried about it. Now, when we started the trial yesterday, I indicated to you that sometime back in November, Ms. Lockwood and Ms. Newton had entered into an agreement that Ms. Lockwood will come to Michigan from Alabama. Ms. Newton, clearly from the testimony that happened, at some point, things didn't go well, and it was requested by Ms. Newton and Ms. Lockwood. However, there was never any formal eviction proceedings. There was an indication from the testimony that Ms. Lockwood may have left the home on the 12th or the 11th of April, and then came back on the 13th, indicating she now knew the rights were. She wanted to get back into the home. She still had some stuff there. She was barred from entering the home by Ms. Newton. There was a testimony that she pushed past Ms. Newton, came into the home, and headed towards the bedroom. At that point, her hair was pulled from behind, and she was hit in the face, which caused damage to her nose, which we saw in the pictures. So the first thing I want to indicate is, even from the people or from the defendant's perspective, they are acquiescing, I believe, by the testimony of their own defendant, that she did strike the victim in the face and that she did pull her hair. So what I want to indicate to you is the judge is going to tell you what the law is, but I'm going to indicate to you this is a case of assault battery. So for me to prove the case of assault battery, I have to prove a couple things beyond a reasonable doubt. First, the defendant committed battery upon Karen Lockwood. Battery is forceful, violent, or offensive touching a person or something closely connected with that person. The touching must have been intended by the defendant. That is, it cannot be accidental. Must have been against Ms. Lockwood's will. Does not matter whether the touching caused an injury or not. Second, that the defendant either intended to commit that battery upon Karen Lockwood, or that she had the ability from Ms. Lockwood's perspective to battery or immediate battery. Now, we also have to prove that this happened at 1140 Kerwood Street, City of Lansing, County, Michigan. We also have to prove that Ms. Newton is the person that committed that battery. I think there was adequate testimony from all the witnesses that it didn't happen in County at 1140 Kerwood Street. The officer identified Ms. Newton, and he was on the stand as the person who he took a statement from, who had indicated to him in her own words that she had pulled the hair from Ms. Lockwood and had punched her in the face. Also, Ms. Lockwood took the stand. I think she indicated that it was Ms. Newton. There was no objection to that, and pulled her hair. So I think we've proven that it did happen in Lansing, and we've proven that Ms. Newton is the person who committed that battery. Now, first, the defendant committed battery upon Karen Lockwood. Battery is forceful, violent, offensive touching a person or something closely connected with that. I don't think by the testimony we've seen, or even by the testimony from the victim, the police officer, or the defendant, that there's no question that the battery was committed. This was a violent or forceful touching. It was done against the will of Ms. Lockwood. I think she was pretty upset. Obviously, you have a crash against your nose unless there's something that part of the body. Second, that this person, Ms. Newton, intended to commit that battery upon Karen Lockwood. It was clear from her own testimony that she said she did grab her and she did punch her in the face. So clearly she did intend to commit that battery. I know that there was a question about whether Ms. Newton was defending herself. Now, a person does have the right to defend themselves, and that has to be that they reasonably believe that they need to protect themselves at that point. Also, that person can only use the amount of force necessary to stop the other person from assaulting them if they believe they're being assaulted. And that would be enough to protect themselves also. So only enough force necessary to protect themselves from imminent assault. And that the defendant has to believe, or that the defendant has the right to protect oneself only as far as it seems necessary. If it's not necessary, so I guess the example I would use is, I was talking about bringing guns to knife fights. If you have a fight and suddenly the fight is over and the other person is walking away, running away, the other person is not allowed to chase them down and then assault on them because the imminent threat is gone. The person is locked at that point. So even assuming, and I'm not going to act this, but assuming there was some contact between the two, I think the testimony was clear that that contact was over, and Ms. Lockwood had headed towards the bedroom, and at that point her hair was pulled and she was punched in the face. So even if there was some type of right to self-defense, and I'm not acquiescing that, but even if there was, I would indicate to the jury that I had the ability to do that had passed because the threat was gone. She had already moved past her and was down towards the bedroom. Now, the officer took the stand yesterday. I think he was the first witness. He responded that he got to the location pretty quick. Said when he got there, he met Ms. Lockwood, took her statement, and took pictures of her, which were memorialized, and they were entered into evidence, and they were presented to the jury. At that point, I think he indicated that Ms. Lockwood indicated to him that there was a dispute over living arrangements at the house. She had found out her rights were at that point. She had not been evicted, and she still had some things in the house, and she was going to go back in the house. I think at that point, he also talked to Mr. Stevenson, who was here to testify. I think he indicated that when he talked to Mr. Stevenson indicated he was sleeping, didn't really see what had happened, although he was helpful in finding Ms. Newton on the phone, giving the officer the phone number. I think he even handed the officer his phone so that the officer could talk with her and then go down and meet her at Taco Bell, which was a few blocks away. One thing the officer did say, however, was that there was never any indication from Mr. Stevenson at the scene that there had been any assault on the part of Ms. Lockwood towards Ms. Newton. And I think he indicated from his perspective that he felt that Mr. Stevens would be less forthcoming at that time based on his experience. And we may say, you know, police officers are on the street every day and they get a little immune to things that go on, and they might make assumptions about, you know, things that happen in the world that aren't really happening at that point just based on their experience. But I think he was pretty clear that based on his experience, he felt that Mr. Stevens was being I think he felt a little less forthcoming about what had happened. He felt possibly Mr. Stevens was trying to protect Ms. Newton. He then indicated he left that location. He went over and met Ms. Newton at the Taco Bell. They had a conversation. The officer was very clear. He saw no injuries on Ms. Newton at that time. At no time did she say she was defending herself. She may have said that Ms. Lockwood had pushed herself into the house past the door, but at no point did she say, I assaulted her because I was defending myself. In fact, he indicated he didn't see any injuries on Ms. Newton. And at that point, made the arrest of Ms. Newton and took her into custody for the assault and battery. Now, later on, Mr. Stevens took the stand. Suddenly his story changed. He saw the whole thing. He heard a boom. He looked up and saw Ms. Lockwood violently push Ms. Newton into the fireplace. And that's what started the whole thing. However, we didn't hear that on the tape. I think all we heard on the tape was that she had pushed her. That's what we heard on the tape. Never did he indicate there was a violent act that tossed her into the fireplace that might have caused some injury. On his own testimony, when I asked him, he told the officer that after he said he did, he said, no, I didn't. The defense presented the tape, which said, asked if he had said this. Then Ms. Newton took the stand. She pretty much mirrored the same testimony as Mr. Stevens, that she had been violently thrown into the fireplace. In fact, she presented some photos that were put into evidence. One photo of an arm, which you'll be able to look at, which had a couple of bruises on it. She indicated she had taken that immediately upon being released from jail the next day. However, when you look at that photo, I want you to look at it very closely. I want you to know there are no extensive bruising there. In fact, those bruises, 2 slight bruises could have happened when she engaged with Ms. Lockwood and committed her assault. I would indicate when you look at the photo, be very careful when you look at it, because it does appear there's no self-authenticating date on there at the time that that photo was taken. Could have been taken at any time. Nonetheless, Ms. Newton testified that she was thrown in the fireplace. However, again, the officer said at no point did she ever indicate that she had been assaulted and that she was protecting herself from Ms. Newton or from Ms. Lockwood. So based on everything I've heard in this case, I asked you a question on jury selection about using your own common sense about how things happen, how things go down. I want you to use your common sense when you run there. And I want you to hold me to the standard. I think we've established that here. There is some counter testimony, but it seems to be very self-serving. In fact, even more self-serving in light of what the officer testified. So there's one thing that's certain. There's one person that was involved in this situation that night who was an impartial person who observed what went on, and that was the officer that took the bait. He was very straightforward in what he said. He corrected himself a couple of times on his statement, but he did not waver on what he thought had happened that night. He's a professional. It's his job to investigate this situation. So at this point, I'm going to ask you to return a verdict of guilty on count of assault battery, indicating that Ms. Newton did assault and batter Ms. Lockwood that night by pulling her hair and punching her in the face. I think we've proven that the end of this movie. Thank you.
Mr. Combs.
Thank you, Your Honor. Put yourself in Kitina's slippers. 5.5 months ago, you just opened your home to a friend in need. The only thing you wanted in exchange was $279 for rent and utilities. Immediately, payments are late, and for the last couple months, they didn't come at all. There were disagreements. Things weren't going well between the two of them, Kitina and Karen. And Kitina asked Karen to leave, and then Karen did exactly that. On April 11th, and we know it was April 11th, for 2 important reasons. One, Kitina's memory was refreshed on that date when shown videos of, when shown a video. 2, Karen told the officer that she had been gone for 2 days with her boyfriend, who lives out of the Detroit area. We found out in trial it's the La Quinta Inn in Southgate, I think. And then, shortly before 11 p.m. on April 13th, 2 days later, you get a text that says, "I'm coming back." And then a few minutes later, 5 minutes if that, Karen's back at 11 p.m. Then Karen pushes her way into the door, pushing you backwards in the process, pushes you up against the fireplace, and is demanding that she be let back in the room that she had just moved out of. All that was left was a bed frame and a mirror, I think is what Kitina testified to. Might you be afraid in that moment? Might you want to do something about it to protect yourself? That's what Kitina did. She grabbed the hair, she punched Karen. There's no doubt about that. But that's not the only thing the prosecutor has to prove. The prosecutor also has to prove that that was not done in self-defense. That is a thing the prosecutor has to prove beyond a reasonable doubt. And when you look at this entire case, as I said before, I think all the evidence points to the fact that this was self-defense. But the prosecutor actually has to prove that it wasn't. The evidence doesn't show that here. We heard from Kitina, basically what I just said. She had opened up her home for 5 months. The rent wasn't coming. The rent stopped. Disagreement followed. She has Karen move out. Karen moves out. We also heard Kitina say that she was pushed twice. She was able to tell you when the photo of her bruises were taken. No, the photo doesn't have a timestamp on it, but if you look through the photos on your phone, you probably notice that most of those don't either. But she was able to tell us when, and she could tell us how she knew when she took it. She did tell the officer she had been pushed. Right, we heard the video. Did she say she had been pushed into the fireplace? No, she didn't get that specific. Did that matter? Or did it matter that she was pushed and she was scared? Both of which she told the officer. She told the officer she was pushed, she was scared. She didn't use the word self-defense because she's probably at that point now thinking that she needs to defend herself in a trial 3.5 months later. Let's talk about Jack's testimony, the not forthcoming Jaquil Stevenson, the boyfriend. Well, he was incredibly forthcoming. He told the officer everything. Everything he told you, he told the officer. And when confronted with that information, the officer walked his statements back. Let's talk about Officer Johnson. He's doing his best with limited information, problematic circumstance. He made a split decision that Karen Lockwood gets to be in the house because there was no formal eviction process. And he's basing that on some amorphous policy that Lansing Police Department has. Officer Johnson's decision on the night in early morning hours of April 13th, April 14th of this year do not bear on your decision. Your decision is to decide whether essentially he got it right. This is why we have juries, because sometimes the government gets it wrong. Let's talk about Karen Lockwood. Always like looking for a good gotcha moment when I get to cross-examine someone complaining that they were a victim of a crime. I don't think there really was one in this case. I was able to cross-examine her on, about when and how she and Kitina met. She told the officer they've been friends since 15, they're best friends in college. And then we find out that they met when she was 17 and they were in college, but wait, no, it was a college. It was like a program to maybe go to a college. And they didn't go to college together. I don't know. Sometimes people mix things up. Not that big a deal. But I think a couple areas where her testimony just doesn't really seem to make sense. One, the glasses, her broken glasses. And then I confronted her with a video, which she acknowledged showed a glare coming from both lenses. She testified that she popped the lens back in. I see 4 glasses wearers in the jury. These aren't, off-the-shelf sunglasses from CVS where the lenses fall out, pop back in. These are prescriptions. I don't think they work like that. And then the entry itself. She testified that she slid by Kitina and made no contact. And I don't think that's possible. Kitina and Ms. Lockwood are both curvier women. It's a standard door entry. There's no way for Kitina to have gotten out of the way by where the fireplace is. If Kitina's really standing in the doorway, I don't think Karen could have then slid by without making any sort of contact. And when we think about her coming into the home, Kitina is standing at the door threshold. Do you think Kitina just gets out of the way at that point? The same person who threw this vicious punch, just a few seconds later, she said, "Come on in, wait, no, I changed my mind, I'm pulling your hair, I'm punching you in the face." It doesn't make sense. So when you look at the totality of the circumstances, when you look at all of the evidence presented in this case, and when you run it through a filter of common sense, which all of you have, the only rational conclusion is that Kitina acted in self-defense. And you might disagree with me, and that's fine, because that's actually not even the question you have to answer. The question you have to answer is whether the prosecutor proved beyond a reasonable doubt that this was not in self-defense. The judge is going to give you the instructions on the law, but I think you're going to have to find that the prosecutor's not met his burden. I'm asking you to find Kitina Newton not guilty today. Thank you.
Any re-argument?
Things gone for 2 days. You've all left your house for 2 days. It didn't mean that you moved out of the home. Many people were away for the weekend. Doesn't mean they left the home.
Speak up, please.
It's true, there was a disagreement between the parties. No one's disputing that. But because there's a disagreement over whether rent was paid or whether the door was left open, or even whether I want you out of the house does not give someone the right to take their fist and smash someone in the face and basically cut the bridge of their nose, which might have required medical treatment. But the victim denied it. It doesn't give you the right to pull that person's hair and turn them around by their hair and punch them in the face. This issue of the rent and the disagreement in light of what we just talked about just now is a red herring. This is about whether Miss Newton punched Miss Lockwood in the face that night and whether she had a right to do that. Christine did not tell the officer that she was pushed into the fireplace that night. Did not say that. And yes, Miss Newton did not say she was pushed into the fireplace that night. You're going to assert self-defense. You can only use the amount of force reasonable, which you believe is reasonable to protect yourself. If someone pushes past you to get through a door, is it reasonable then to grab them by the hair, turn them around, bash them in the face with your fist so that you cut their nose and break their glasses so that the lens pops out of their glasses and then flee the home and go somewhere else? I would propose to you it's not reasonable. You can only use the amount of force necessary to protect yourself at that moment. It's clear from all the testimony, if there was any contact, that moment had passed. Ms. Lockwood was past her and she was headed to the bed. Don't get to then up the fight. You can only use that force as long as you reasonably deem that to be necessary. Once a person is by you and they've gone past after they pushed you out of the way, even assuming they did push you out of the way, that doesn't give you the right to follow them, grab their hair, bash them in the face. Just doesn't. All this stuff about the rent and getting in the house and disagreements, as I said, that's all a red herring. This is about whether there was an assault that night. It's clear. You've seen the pictures. You've heard all the testimony. Everybody agrees there was an assault. So the question you have to ask yourself is, was that assault reasonable? As a self-defense, I would indicate to you it was not. And I'm going to ask you to bring back a verdict of guilty on assault and battery. Thank you.
Okay, ladies and gentlemen of the jury, if you can fix your attention to the screen, I have one final set of instructions before you are released to do your most important duty. Let's see. Members of the jury, the evidence and arguments in this case are finished, and I will now instruct you on the law as it applies in this case. Remember that you have taken an oath to return a true and just verdict based only on the evidence and my instructions on the law. You must not let sympathy or prejudice influence your decision. As jurors, you must decide what the facts of this case are. This is your job and no one else's. You must think about all the evidence and then decide what each piece of evidence means and how important you think it is. This includes whether you believe what each of the witnesses said. What you decide about any fact in the case is final. It is my duty to instruct you on the law. You must take the law as I give it to you. If a lawyer says something different about the law, follow what I say. At various times, I have already given you some instructions about the law. You must take all my instructions together as the law you are to follow. You should not pay attention to some instructions and ignore others. To sum up, it is your job to decide what the facts of the case are, to apply the law as I give it to you, and in that way, decide the case. A person accused of a crime is presumed to be innocent. This means that you must start with the presumption that the defendant is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty unless you are satisfied beyond a reasonable doubt that she is guilty. Every crime is made up of parts called elements. The prosecutor must prove each element of the crime beyond a reasonable doubt. The defendant is not required to prove her innocence or to do anything. If you find that the prosecutor has not proved every element beyond a reasonable doubt, then you must find the defendant not guilty. A reasonable doubt is a fair, honest doubt growing out of the evidence or lack of evidence. It is not merely an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after a careful and considered examination of the facts and circumstances of this case. When you discuss the case and decide on your verdict, you may only consider the evidence that was properly admitted into this case. Therefore, it is important for you to understand what is evidence and what is not evidence. Evidence includes only the sworn testimony of the witnesses, the exhibits admitted into evidence, and anything else I have told you to consider as evidence. Many things are not evidence, and you must be careful not to consider them as such. The fact that the defendant is charged with a crime and is on trial is not evidence. The lawyer's statements and arguments are not evidence. They are only meant to help you understand the evidence in each side's legal theories. You should only accept things the lawyers say that are supported by the evidence or by your own common sense and general knowledge. The lawyer's questions to the witnesses and my question to the witnesses are also not evidence. You should consider these questions only as they give meaning to the witnesses' answers. My comments, rulings, questions, and instructions are also not evidence. It is my duty to see that the trial is conducted according to the law and to tell you the law that applies in this case. However, when I make a comment or give an instruction, I am not trying to influence your vote or express a personal opinion about the case. If you believe that I have an opinion about how you decide the case, you must pay no attention to that opinion. You are the only judges of the facts, and you should decide this case from the evidence. At times during the trial, I have excluded evidence and I have offered or stricken testimony that was heard. Do not consider those things in deciding the case. Make your decision only on the evidence that I let in and nothing else. Your decision should be based on all the evidence regardless of which party produced it. You should use your own common sense and general knowledge in weighing and judging the evidence, but you should not use any personal knowledge you may have about a place, person, or event. To repeat once more, you must decide this case based only on the evidence admitted during the trial. As I said before, it is your job to decide what the facts of this case are. You must decide which witness you believe or witnesses you believe and how important you think their testimony is. You do not have to accept or reject everything a witness said. You are free to believe all, none, or part of any person's testimony. Okay. Okay, I can't make it full screen anymore. I don't know what's going on. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe, there it goes, a witness's testimony, you must set aside any bias or prejudice you may have based on race, gender, or national origin of the witness. You have heard testimony from a witness who is a police officer, or witnesses who are police officers. Here we had one police officer. That testimony is to be judged by the same standard you use to evaluate the testimony of any other witness. There is no fixed set of rules for judging whether you believe a witness, but it may help you to think about these questions. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might distract the witness? Does the witness seem to have a good memory? How did the witness look and act while testifying? Did the witness seem to be making an honest effort to tell the truth, or did the witness seem to evade the questions or argue with the lawyers? Does the witness's age or maturity affect how you judge his or her testimony? Does the witnesses have any bias, prejudice, or personal interest in how this case is decided? Have there been any promises, threats, suggestions, or other influences that affected how the witness testified? In general, does the witness have any special reason to tell the truth or any special reason to lie? All in all, how reasonable does the witness's testimony seem when you think about the other evidence in the case? Sometimes the testimony of different witnesses will not agree, and you must decide which testimony you accept. You should think about whether the disagreement involves something important or not, and whether you think someone is lying or is simply mistaken. People see and hear things differently, and witnesses may testify honestly, but simply be wrong about what they thought they saw or remembered. It is also a good idea to think about which testimony agrees best with the other evidence in the case. However, you may conclude that a witness deliberately lied about something that is important how you decide the case. If so, you may choose not to accept anything that witness said. On the other hand, if you think the witness lied about some things but told the truth about others, you may simply accept the part you think is true and ignore the rest. The prosecutor must also prove beyond a reasonable doubt that the crime occurred on or about April 13, 2023 within the city of Lansing, Ingham County. When you go to the jury room, you may take a written copy of the jury instructions with you along with your notes. You should first choose a foreperson. The foreperson should see to it that your discussions are carried out in a businesslike way and that everyone has a fair chance to be heard. During your deliberations, please turn off your cell phones or other communication equipment until we recess. A verdict in a criminal case must be unanimous. In order to return a verdict, it is necessary that each of you agrees on that verdict. In the jury room, you will discuss the case among yourselves, but ultimately each of you will have to make up your own mind. Any verdict must represent the individual considered judgment of each juror. As you discuss the case, you should think about all my instructions together as the law you are to follow. It is your duty as jurors to talk to each other and to make every reasonable effort to reach an agreement, express your opinions and reasons for them, but keep an open mind as you listen to your fellow jurors. Rethink your opinions and do not hesitate to change your mind if you decide you were wrong. Try your best to work out your differences. However, although you should try to reach agreement, none of you should give up your honest opinion about the case just because other jurors disagree with you or just for the sake of reaching a verdict. In the end, your vote must be your own, and you must vote honestly and in good conscience. Possible penalty should not influence your decision. It is the duty of the judge to fix the penalty within the limits provided by the law. If you want to communicate with me while you are in the jury room, please have your foreperson write a note and give it to my court officer. It is not proper for you to talk directly with the judge, lawyers, court officers, or other people involved in the case. As you discuss the case, you must not let anyone, even me, know how your voting stands. Therefore, until you return with a unanimous verdict, do not reveal this to anyone outside of the jury room. When you go to the jury room to deliberate, you may take your notes with you and the full instructions. If you want to look over any of the reference documents or exhibits that were admitted, just ask for them. I have people with 3 exhibits and the defense with 1, correct? When you go to the jury room, you will be given a copy of my written instructions that you have just heard. As you discuss the case, you must think about all of my instructions together as the law you are to follow. You may return a verdict of guilty of the alleged crime or not guilty. I have prepared a verdict form with listing the possible verdicts. The prosecution has introduced evidence of a statement that it claims the defendant made. Before you consider such an out-of-court statement against the defendant, you must first find that the defendant actually made the statement as given to you. If you find that the defendant did make the statement, you may give the statement whatever weight you think it deserves. In deciding this, you should think about how and when the statement was made and about all the other evidence in the case. You may consider the statement in deciding the facts of this case, and in deciding if you believe the defendant's testimony in court. Facts can be proven by direct evidence from a witness or exhibit. Direct evidence is evidence about what we actually see or hear. For example, if you look outside and see rain falling, that is direct evidence that it's raining. Facts can also be proved by indirect or circumstantial evidence. Circumstantial evidence is evidence that normally or reasonably leads to other facts. So taking that same example, if you see a person coming from outside wearing a raincoat covered with small drops of water, that would be circumstantial evidence that it's raining. You may consider circumstantial evidence. Circumstantial evidence by itself or a combination of circumstantial evidence and direct evidence can be used to prove the elements of the crime. In other words, you should consider all evidence that you believe. You may consider whether the defendant had a reason to commit the alleged crime, but a reason by itself is not enough to find a person guilty of a crime. The prosecutor does not have to prove that the defendant had a reason to commit the alleged crime. He only has to show that the defendant actually committed the crime and that she meant to do so. The defendant's intent may be proved by what she said, what she did, how she did it, or by any other facts and circumstances and evidence. You should not decide the case based on which side presented more witnesses. Instead, you should think about each witness and each piece of evidence and whether you believe them. Then you must decide whether the testimony and evidence you believe proves beyond a reasonable doubt that the defendant is guilty. The elements of the charge are: the defendant is charged with the crime of assault and battery. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant committed a battery upon a Karen Lockwood. A battery is a forceful, violent, or offensive touching of the person or something closely connected with the person of another. The touching must have been intended by the defendant, that is, not accidental, and it must have been against Karen Lockwood's will. It does not matter whether the touching caused an injury. Second, that the defendant intended either to commit the battery upon Karen Lockwood or to make Karen Lockwood reasonably fear an immediate battery. The definition of a touching: for a battery to occur, the touching must have been intended by the defendant, that is, not accidental, and it must have been against, in this case, Karen Lockwood's will. It does not matter whether the touching caused an injury. An assault does not have to cause an actual injury. However, if there is or was an injury, you may consider the injury with the other evidence in determining whether there was an assault. Burden of proof for self-defense. The defendant does not have to prove that she acted in self-defense. Instead, the prosecutor must prove beyond a reasonable doubt that the defendant did not act in self-defense. Use of non-deadly force in self-defense or in defense of others. The defendant claims that she acted in lawful self-defense. A person has the right to use force to defend herself under certain circumstances. If a person acts in lawful self-defense, her actions are justified and she is not guilty of the crime of assault and battery. You should consider all the evidence and use the following rules to decide whether the defendant acted in lawful self-defense. Remember to judge the defendant's conduct according to how the circumstances appeared to her at the time that she acted. First, when she acted, the defendant must have honestly and reasonably believed that she had to use force to protect herself from the imminent unlawful use of force by another. If her belief was honest and reasonable, she could act at once to defend herself, even if it turns out later that she was wrong about how much danger she was in. Second, a person is only justified in using the degree of force that seems necessary at the time to protect herself from danger. The defendant must have used the kind of force that was appropriate to the attack made in the circumstances as she saw them. When you decide whether the force used was what seemed necessary, you should consider whether the defendant knew about any other ways of protecting herself, but you may also consider how the excitement of the moment affected the choice the defendant made. Third, the right to defend oneself only lasts as long as it seems necessary for the purpose of protection. Fourth, the person claiming self-defense must not have acted wrongfully and brought on the assault. However, if the defendant only used words, that does not prevent her from claiming self-defense if she was attacked. That does conclude our jury instructions. We will swear Mr. Bigelow in so that he can take the jury back. At this point, you will receive a copy of my total jury instructions. You can take your notes with you. You will be free to deliberate and discuss. If you need to see any of the exhibits or if you have any questions, you'll have your foreperson provide that on a written sheet of paper to me without disclosing to me where your voting lies. Mr. Bigelow, can you raise your right hand? Do you solemnly swear or affirm that you will, to the utmost of your ability, keep the persons sworn as jurors on this trial from separating from each other, that you will not suffer any communication to be made to them or of them orally or otherwise until they have rendered their verdict? So help you God. Thank you. You may be excused to deliberate. Hello. I see Joe Lucas. Can you hear me?
Yes, I can. Joe Lucas here. I'm on case 3-01267 GP.
Okay. I'm actually in the middle of a jury trial, so we did reset your matters. However, you are just here for a pre-trial, so I can put you both in a private meeting room. you can work out a joint pretrial statement and submit it to the court. Or if you come to a resolution, then that works as well, okay?
Sure.
Theophilus Harvey, can you hear me?
Yep, I can hear you.
Okay, very good. So I'm gonna put you both in a breakout room. If you do come to an agreement, or if you come to, or complete your joint pretrial statement, Mr. Lucas, you can just submit that to Judge Simmons Courtroom at lansingmi.gov.
Do I have a joint pretrial statement is the next question. I don't think I do.
Okay, Mr. Bigelow would have sent you one to complete prior to today.
All right, let me see. This could be it. Nope. Probation.
What's your email?
It's JAL@velolaw.com.
Did you catch that?
Are you ready?
Spell
JAL@velo law.com.
Yellow. Okay. Okay, one should be coming to you shortly, and I'm gonna put you both in a breakout room.
All right, that sounds good. And then we'll fill that out and submit it. And where do I submit it again? I'm sorry.
It's
What's
Judge
the-
Simmons Courtroom at lansingmi.gov.
Judge Simmons, SIMMONS Courtroom. That's a long one.
It is
At at what is it again? I'm sorry. At
lansingmi.gov.
okay, Judge Simmons Courtroom at lansingmi.gov. Okay, if we're able to fill the thing out, I'll submit it.
Wonderful, thank you. If not, we'll just continue to your reset date and we can do whatever we need to do on the record.
Has there been a reset date set?
There has been. Let's see what it do is look back. Looks like it was reset for August 17th at 8:30. Nope, 9:30.
9:30. Okay. All right. I will wait for this thing to come through and then we'll go from there.
Thank you. And let me. One.